Hey everybody, we're about to get started on the live radio show, Aging Insight. Hope you enjoy the program today. If you have any questions or comments, feel free to just drop them down in there. We'll see them as they come up. So feel free if you got a question, you just want to say hi, whatever works. We're here. So got the opening intro music playing. All the disclaimers about, this is not legal advice.
Do not personal legal advice.
Do not rely on this without consulting with your own attorney and all of that good stuff. So, all right, here we go. John Ross and Lisa Shulman. Welcome to Aging Insight, everybody. This is your host, John Ross, here live in the studio. You are listening to the #1 program related to your health, housing, financial, and legal needs, brought to you by the king and queen of elder law.
Yes.
John Ross and Lisa Schulmeyer.
I'll take it.
Yeah, why not? I just make stuff up anyway. I mean, we can definitely say we're the best program.
Well, yeah.
Because we're the only program.
That's right.
Yeah, so it's good. It's good to be us, as far as that goes. Yeah. But we come in here every Saturday. We're live. It's June the 1st.
It is.
Summer in full swing. The sun is shining. You're sitting out by the pool. Your radio's on, getting some education on elder law.
That's right. So we come to you live from the beautiful studios in downtown Texarkana, and we do that pretty much every Saturday. Pretty much. And we do that because we have some sponsors that help throw in some coin to make it happen. So just want to give a special thanks and a shout out to Red River Federal Credit Union, Cowhorn Creek Estates, Heritage Plaza, Texarkana Funeral Home. You're going to tell me Dirksen Hospice. I'm trying to rattle them off from the top of my head.
Edgewood?
Oh, Edgewood Manor. Yeah, their commercial opened our show today. Also Reunion Plaza, the Barnett Agency, specializing in Medicare supplement and insurance type needs. Also Texarkana Hospice. And did I miss anybody?
Did you? I don't know. Did you say Texarkana Funeral Home?
I did.
Did you say Cowhorn Creek Estates?
I did. You weren't listening.
I really wasn't. But
yeah.
You know what? If you are listening to us live on the radio, the one thing you can do is you can always go to our Facebook Live. We do this live on Facebook as well as live on the radio. The cool thing is about the Facebook stuff is even if you miss part of today, or you want to go back, or you hear something today that you just think, you know what, my friend needs to hear this, then you can direct them to the Facebook Live and give us a shout.
Yeah, so besides hauling our cookies up here every Saturday, the airtime is it's helped paid for by these sponsors. If you do business with these folks, please let them know that you appreciate it. And John, what's been going on? Well,
I guess we got a couple of things coming up this week. We always like to talk about where we're going to be out there in the community.
Where we're going to be, where we've been.
And now that we're back on 107.1, we do have a broader range. We've got a little more powerful,
more wattage. Yes.
And so I think we're back in the Hope area.
Okay, so that they can hear us up there in Hope, a little bit north here.
That's right. And so I will be up in Hope on Thursday. We do our Aging Insight live programs.
Yeah, so you're listening to Aging Insight on the radio, but when we get out in the community and speak, Aging Insight is live in your community.
That's right, and we'll be in Hope on Thursday there at, I believe it's Unity Baptist Church.
Yes, right near the downtown area.
Yeah, and so we'll be over there. It's noon. It's free lunch and a great educational opportunity. I think my topic is on trusts.
I believe it is.
So all the different types of trust. In fact, there's about 4 types of trust that almost everybody could benefit from at least one version of them in their estate planning. So that'll be my topic. So, you're welcome to just haul your cookies from Texarkana up to Hope if you want to see me. But if not, if you'd like to see me without hauling your cookies to Hope, then all you got to do is wait one more day.
Yes. So on Friday, June 7th, Is that what day that is?
Yeah, Friday, June 7th. I don't know.
Yeah. Well, today's the 1st, so maybe that would be the 6th. We're looking.
Let's go with
Friday, June 7th. I was right.
Yeah, Friday, June 7th.
Yes, Friday, June 7th is the Senior Expo here in Texarkana, and that will be taking place at the Texas Side Convention Center. And that is, lots of booths, lots of free giveaways.
Yep.
Always big time. I kind of refer, it's some adult trick-or-treating.
That's right.
There'll be some jar openers. There'll be some, pill containers. There'll be some candy and goodies around.
Yeah,
Yes,
there'll be all
right.
kinds of stuff.
So see lots of service providers, people that serve the senior community will be out at Senior Expo. I believe, John, they are having a breakfast with the experts, with some, doctors and medical folks.
Yep.
And then you are the draw, the lunch and learn speaker.
Yep, that's right. We're going to have they're going to have a lunch presenting John Ross, where I will talk about some of the fundamentals of estate planning and everything that you ought to have in your own stuff.
So that's Friday. Now, that Senior Expo, it's been going on several years. I don't know which one this is, but I do know that it is busy in the morning of that Senior Expo.
Oh yeah.
If you want to get out and get the best goodies and get talk to folks, I think you either come early or late.
That's right.
Because it's pretty busy in the middle there. But I know they'll appreciate you coming out, and I know, John, you'll like to see a lot of faces at the lunch presentation. So come on out for that. So mark your calendar.
That's right. All right. Well, we got an interesting topic for you today.
We think so.
Well, we are, of course.
We always think so.
but we were thinking, trying to come up with some ideas. So we were reading a few recent cases.
Yeah, because that's what we do for fun. Is we read elder law cases.
Yes, it's the kind of nerds that we are.
Yes.
And we were reading a recent case, a 2019 case.
Yes, a 2019 case that is set right here in East Texas.
Yeah, down in the Tyler area.
Yeah, Tyler. Sometimes we come on the show, John, we talk about facts and cases of things that are going on, California, wherever. No, this was right here in East Texas, out of the Tyler Court of Appeals. And it had to do with whether or not a lady's last will and testament, whether that should be probated and honored with her wishes that she set out in that document.
Or whether it was invalid in some way, shape, or form.
Yeah. So basically, we had a will contest go down in Tyler, Texas. I don't know. I think the Tyler court, we'll get into the facts and the story of what happened. But I don't know. The case seems a little, it seems a little newer, looser with the rules than what we've always thought.
Yeah, maybe they may have just screwed it up.
Yeah. So.
But I'm not saying that it's, the problem you will often see is that in the legal world is you have laws, but you have those laws being enforced and interpreted by people. While the laws have a tendency to be very black and white, the people see a whole lot of gray.
Yeah.
And isn't there a famous quote or something of bad facts make bad law?
Yep, bad facts make bad law. So because the law is so pristine and says this is what should happen in this type of situation, but then the facts are never, the facts are always messier than what the law really contemplates. And it's funny, John, you talk about people in the system, the judge, the lawyers, they kind of muddle things.
That's right.
Remember we had a caller, I don't know, a week or so ago, a couple of weeks about maybe AI is the way to go. And I think that was talking about medical decisions, but maybe if we just plugged all the facts into the computer and asked the computer whether or not this violates the law.
But it does may take the emotion out of it.
Yes. And so we have a case here in Tyler, Texas. And first thing, we're going to talk about whether this will of this lady should have been probated. And the big question, John, was the lady who made the will, was she unduly influenced into making the will she made?
Yes.
And
the claim of undue influence.
And so we're going to unpack the requisite legal requirements to prove a claim of undue influence today. But John, before we jump into the law, how many times would you say we have met with clients that have basically brought that potential up, as we're talking to them?
More than I can count. That's for dang sure.
Yeah, because
I've had that conversation with more people that we don't feel that, we don't think mom's will is valid because, brother, son, daughter, spouse, whoever, tricked them into doing it, influenced them, pressured them into doing it.
Yeah.
They didn't know what they were doing. The other person pressured them into doing it.
Yeah, no. One situation I've seen over and over again is the child that has been estranged from the family for years and years and years, and as the parent becomes more frail, health declines, the black sheep child swoops back into the family orbit, and before you know it, that parent makes a will, fully including the child they had previously disinherited, or even better, making that black sheep child who's now back in their life, the sole beneficiary of their will. So we get this all the time. We get this from blended families where mom passed away a few years ago, dad remarried to lady friend from church. We thought she was wonderful, but then dad died and he left her everything in the will.
Right.
And I know dad didn't want to do that. He told us that he had left things in a certain way, but the will doesn't say that. So, and he never told us he changed the will. So that woman influenced dad to go change. So the idea of undue influence is very, very common in families and in situations. We have listened to more stories about the potential of an undue influence claim. And John, in all those years we have listened to those stories, I can think of only a handful of times where I felt like the facts as presented were maybe warranted, further potential litigation on that issue.
Right.
And so it's a very hard claim to prove, or at least maybe before this Tyler case, it has always been. So we're gonna jump in and talk about that. But John, the other thing I wanted to point out to our listeners before we jump in the facts of this particular case out of Tyler is undue influence. Well, I guess this starts getting into the Tyler case. There was almost no money in this Tyler case. I mean,
no, there really wasn't.
And so we have people tell us all the time, oh, I don't need to do any estate planning. I don't need to do any pre-planning because I don't have anything. Well, this lady that we're going to talk about out of Tyler, she didn't have much, but it was enough to generate a trial and enough to generate an appeal. And that's a lot. So anyway, so this case has East Texas written all over it, some pretty modest state. The facts are pretty common that we see in our area. So let's take a commercial break and then we'll come back and jump in. Yeah,
sounds like a plan. Stick around. We'll be right back.
Aging in sight.
All right, and we're still live. I will say that when I set up the Facebook Live at home and I'm uploading photos and getting the little scrolly banners and doing all of that, everything runs really smooth. When I get up here to the radio station and I connect to their computer system, their network, everything slows way down. So I would not necessarily blame your own internet connection problems. It's probably ours, if I were guessing. They could probably use an upgrade here at the radio studio. Probably.
Well, this radio studio.
Right, it's not internet studio, I suppose.
Marconi could be around somewhere.
But yeah, I can tell just on my own system that things run slower here than they do, say, at my house. So I figure if you're out there watching, that's probably the deal. If you're getting some stutters. All right. Well, we've got. Again, y'all come out if you do catch us out there in Hope. Now we're today we're also broadcasting this out across our Ross and Schollmeyer Longview and Ross and Schollmeyer Tyler websites, Facebook pages as well. So we're reaching out to some of those communities. So if anybody else is interested down there in the Tyler area, I will be speaking in Athens on Tuesday. So, if you got any friends in Athens that you think need this information, tell them to come out at noon at First Baptist Church there in Athens, Texas, and come listen to me speak. Topic is leaving a legacy. How your decisions now impact your family's future. I don't know what that means.
Well, but I'll know by Tuesday.
But by Tuesday, I will know what exactly that means. No, we joke a lot because we've been doing this so long that we need very, very little preparation for these speeches. We've spoke on these topics hundreds and hundreds of times, and teenagers, man. We literally have this kind of running gag every week because we've been doing the radio show for 5-6 years, and inevitably one of our teenagers tries to call or text us during this hour. Every time. And we just got another one. So, all right, here we go, back live.
Do you remember these people's names in this case?
No.
Question, phone 903-793-1071. Now back to Aging Insight with John and Lisa.
Well, welcome back, everyone, to Aging Insight. This is Lisa Schollmeyer, and I'm here with John Ross. And today we're talking about the claim of undue influence, which has to do with whether or not a last will and testament is a valid last will. The idea here is if someone so influenced you to make the will that you made, and that is not what you would have normally done, well, then the will's not valid because your own judgment was obliterated by this influencer.
Right. I mean, we do a speech on how to draft your own will, and I always open up that speech by talking about the requirements to make a will before you ever put pen to paper. That one of the things you have to have is you've got to have testamentary capacity. You've got to have the right frame of mind. Now most of the time you think about that in terms of, are you
conscious?
Right.
Are you with it? Or do you know what's going on around you?
Yeah, do you have the brain power to do it, or have you had a catastrophic brain injury that prevents you from being able to make decisions, right? So most people think of it in that terms. But the idea behind undue influence is that the person still, even though maybe they have the mental capacity to make decisions, they still lack testamentary capacity, the ability to make a will, because of the pressure.
Right. We know what this is. You think about a POW or someone who's been captured by the enemy and they're on video praising their captors and what a wonderful place this is. Well, we know that is undue influence.
Right.
but so we kind of take that same tack here in the last will and testament area. So we have a case out of Tyler, Texas. And so we have a lady who is older. She's ill.
Yep.
She's also, John, going through a divorce.
Yeah.
So we got a lot of emotional stuff going on here.
Yeah, so we don't exactly know what all is going on, but yeah, she was in the process of getting a divorce. She's very sick. A lot of the stuff that we read related to this case, it didn't really get into the details of who these people were, right? When you're reading cases, they're not news articles. You don't have them doing a whole lot of background and
so here we have the testator. So we have this lady who is going through all this emotional stuff, and John, going through this divorce, it appears that her adult children had taken the side of her estranged husband.
Yes.
So the kids are backing husband in this divorce, and these are all adults. So anyway, this lady being sick and having health issues and going through this is befriended.
She is, yeah. So the lady who's getting the divorce, the testator in this case, she's got a sister, and her sister has a friend. So it's the testator's sister's friend.
Yeah. So the sister introduces her to a new friend.
Yes, and this friend steps in and kind of described as befriended her.
Yes.
Takes her to doctor's appointments, takes her to the hospital, and actually continued to help her with the divorce proceeding stuff.
Yes. So it was clear that the testator in this case, she could not provide her own transportation. We don't know whether that was a physical or health issue, what it was, but she could not provide her own transportation. So her new friend would transport her around to doctor's appointments and errands and things like that. Also, her new friend was very emotionally supportive to her as this divorce proceeding played out, and also provided lots of care and company.
That's right.
To the testator.
And there was even a text message, so that ultimately this lady's doing all of that, and there's not a lot of relationship with the kids, right? There's some estrangement going on.
Yes.
Interestingly, so the lady dies. She dies before
the divorce was final.
The divorce is final. It's all wrapped up in the middle of a mess there, but she dies, and she does leave behind a will.
Great. She's done more than 75% of the folks, so she left a will.
That's right, but she leaves a will, and the primary beneficiary, in fact, believe the sole beneficiary.
Yeah, the only beneficiary
is this friend.
It's the new friend.
That's right. And so you can imagine.
The kids didn't like this.
Yeah, you can imagine the kids ain't happy about it, and so they're going to challenge the will, and we're going to talk about that challenge and what that means, and everything you'll need to know. Stick around. All right, and we're back.
Yes.
And I'll probably mention this when we come back, but I was reading here. I like the way they put this. The decedent's phone texted her attorney that she wanted to draft a will and name her friend as the sole beneficiary.
Yes, the phone texted the attorney. But I mean, what that's showing is that the attorney only knows they got a text. They certainly don't know who was behind the phone actually doing the texting.
Yeah.
We've seen that.
Yeah, we've had actually got a call this week from one of my clients asking if I would send them a copy of their trust that we had prepared. Yeah. And one of my assistants actually took the call, and then she came in and she said, they want me to send it, and they want me to send it to Robbins Toyota. And I was like, that's weird, anyway, they left a callback number, but I didn't call that callback number. I called the number I had for them. Right. And I got the guy and was like, what's going on? He was buying a car. and he was titling the vehicle into the name of his trust.
Mhm.
And so I just sent and in that case, I sent the certification of trust, which is just the summary that doesn't get into the details of it. So not something that, but that's something that would be generally a public record anyway. Those are often filed at court because they don't tell any damaging information. They don't tell you who gets what when they die. They don't tell you any of that secrety stuff.
Right. Yeah. Well, that's kind of funny because I was at a different car. I was at a car dealership this week, having my car inspected, and I was in the waiting room, and there was a young lady who was wanting her grandmother's will to be sent over to the dealership. She was trying to buy a car. And when it was proving that she was a beneficiary under this estate.
Oh.
So I thought the finance, I was eavesdropping. But I mean, you're in the waiting room. What are you going to do?
Yeah, you can't help it. Yeah.
And it was an elder law issue. Anyway, and the young lady and the finance guy with the car dealership, they were all over it. I really wasn't sure how sending a copy of the will was going to help her finance this car, but whatever.
Yeah,
I was incognito, so nobody asked me my opinion about it. But
that's interesting. I hadn't heard that. That's pretty interesting. You will see people that'll try to get loans against estates or loans against trusts. Generally speaking, if it's a properly drafted will or a properly drafted trust, a beneficiary is going to be prohibited from doing that. This is what's called a spendthrift clause. And you'll see that most wills, or at least most appropriately drawn wills and most appropriately drawn trusts, will have this spendthrift clause in them that actually prohibits the beneficiary from being able to encumber their share.
Yeah, to promise somebody else something from the estate.
So yeah, even if that car dealership did take some sort of security interest in her share of the estate, that would probably be void.
Yeah. I refer to that as the Wimpy hamburger clause. You know how the character Wimpy would say, "I'll gladly pay you Tuesday for a hamburger today." So that's how I usually explain that to my clients, that we're not letting anybody promise anything from the will or trust for something they could get today. So anyway,
that's right. So that generally doesn't work.
Yeah. So but that's interesting that in the case that the court, you can tell that the court in that case did not, they were a little skeptical.
They were a little
when
skeptical.
They were saying the client's phone texted the attorney.
Right.
A phone can't do that. So, I mean, on its own. So
right. Yeah.
There was somebody behind it, and the court clearly wasn't buying it was the client.
That's right. Okay, we're going back live in about 10 seconds. Appreciate y'all watching, and feel free to share out there if you'd like the information. All right, here we go.
Phone 903-793-1071. Now back to Aging Insight with John and Lisa.
Welcome back to Aging Insight, everybody. This is your host, John Ross, here live in the studio with my co-host, Lisa Schulmeyer. And today we are talking about a Tyler case on the issue of undue influence.
Yeah.
We have a woman who is in the middle of a divorce. By all accounts, her children have taken the side of her husband. Didn't say husband, but I'm going to assume husband. So her children have taken the side of her husband. She, meanwhile, is befriended by an acquaintance who steps in and carts her to doctor's appointments and helps her with stuff like that. And in the end, this lady dies before the divorce is even final. So she was obviously very, very sick.
Right.
And after she dies, a will is presented where this lady purports to leave her entire estate to her friend.
To her fairly new friend.
To her fairly new
So,
friend.
a couple things about it too, John, that pointed out is one, the kids, like I said, we did talk about the kids being somewhat estranged from mom because of them picking sides in the divorce. Also, the will that was presented to the court for probate that named the new friend as the sole beneficiary and excluded the lady's children, it was actually signed in the lady's home.
Yes, they did it
So the
at
will
the
was not
house.
done at an office or anything like that.
Yep, that's right. So it does happen.
Sure, we do execute wills all the time in people's homes. Sometimes health and circumstances prevent them from getting out. But in this case, the will was signed in the lady's home. Her new friend and her new friend's husband were both present at the signing of the will.
Yes. Yeah. So, we before the break, I made the quote of bad facts equal bad law. We got some bad facts in this
Yeah,
deal.
yeah, we really do.
This friend was apparently not a great personal financial manager in their own right.
Right. Well, actually, no, I think the new friend was a criminal.
Oh, was it? Yeah, they were
Yeah,
just
they were on
outright.
deferred adjudication.
Ah, yes.
So the new friend was on deferred adjudication, which is basically the prosecutor in a criminal matter is kind of taking a wait and see approach. And the new friend apparently had had committed some sort of financial fraud.
Yeah, and had been ordered by the court to pay back over $38,000 as a result of their theft.
Yeah. So the new friend had a kind of an axe hanging over their head from the court in an unrelated matter to pay back some money. So that was in play here. Also, but John, this is where I talked earlier segment. This lady's estate, the decedent, her whole estate was worth like $28,000.
Right.
So if you're listening out there, I want you to take a look around the room, think about what you got in the bank, think about the car sitting in the carport or the garage. A $28,000 estate is a very modest estate.
That's a small estate.
So, here we have a lady who didn't have much, but yet this friend who had some obligations to pay back some financial fraud, criminal fines here. She swooped in and became the best new friend.
Well, and that does bring up the point of when people say, you know what, John, I don't have enough for anybody to fight about. Enough. What's a lot or a little is very personal.
That's right.
If you are completely broke, and on top of being completely broke, the judicial system $38,000, or you're going to go to jail.
Yeah.
Then
a small modest estate that isn't yours that you can get your hands on.
Yeah, all of a sudden that's a lot.
Yeah. So
to the lady dying and leaving her piddly estate to her friend. Yes. She may very well have thought of that as being a pittance. Right. This is not enough for anybody to fight over. Yeah. It was certainly enough. It certainly it certainly was.
Yes.
In this case.
So what happens is the friend, after the lady's death, the friend offers the will to probate. So they file the will with the court, offering it for probate, and the deceased daughter contests the will, saying that the will now being offered, which leaves everything to mom's new friend, is invalid because the will was executed due to the undue influence of mom's new friend, which, leaving everything to the new friend under the will. So daughter comes in and contests. Now, this is the same daughter, John, that had taken dad's side. So again, not a great fact, I suppose,
Right.
But the daughter did bring evidence to the court that said she had tried to repair her relationship with her mother and to rebuild some bridges that had apparently burned due to this divorce. And she was prevented from doing so because mom's new friend was isolated her mother from any family.
Yeah, and if you've ever heard Lisa and I do our playbook of an abuser speech, that is one of the key elements.
Yeah, just
Isolation.
isolation. That's right. So daughter claims that there were a lot of issues in the divorce, but she had made overtures to rebuild that relationship, and she was rebuffed and prevented from doing so by mom's new friend.
That's right. And so she makes the claim. The daughter makes the claim that this new friend has unduly influenced her mom. And so her mom then would have lacked legal testamentary capacity. She didn't have the mental wherewithal to make a valid will because of the influence by this person, and wins.
And yes, the daughter wins the case. And so the new will made to the friend is thrown out.
That's right. And so, there's lots of undue influence cases out there. I will say most of them are losers.
Right. Undue influence under the law is not that you just simply left your stuff to someone besides your kids. The Texas law has been very, very strict about trying to prove undue influence, because the bottom line, John, is you're a free American. You can do with your stuff whatever you want to do with your stuff.
And you can be dumb about it.
That's right.
That's one of the hardest things for a lot of people to understand, is that you can do stupid things without that being rising to the level of overpowering you. So we've got three basic elements when it comes to undue influence, and this has been across the board. Now, this Tyler case gets all into the weeds, but we've got three basic elements, and the first is there has to be the existence and exercise of an influence.
Right. So.
Right. But that's very easy to prove.
Sure.
Right. If I saw you at the you're one of the listeners, right? And you come up to me at Walmart on a Sunday when I'm doing my grocery shopping, and you say, "Hey, I recognize your voice. You're John Ross." And I say, "Yeah, I am John Ross. Do you like the show?" And you say, "Yeah, I like the show." I say, "Great. Well, then why don't you leave me part of your estate
so we can keep doing the show? And
if you do, I will give you a pat on the back, and I'll even mention you on the radio."
Yeah. So John, you are attempting to influence.
I'm certainly trying to exercise some influence on this deal. So influence is pretty easy. And in most of the cases when people are making these claims, they're talking about their, it was the caregiver, it was the sister that was there in the house with them or something like that.
It was the new girlfriend.
Yeah, it's the new girlfriend, whatever it was. But it's the next two that are really the typical problem. And that's that the influence was so strong that it overpowered the testator's mind at the time the will was executed, and that they wouldn't have done it except for that influence.
Yeah. So we have influence that is overpowering.
Yeah. And overpowering to the point that they had no choice. They couldn't refuse this. That's what it is. The classic example is I hold a gun to your head and say, "Sign this or I pull the trigger."
Yeah, that is absolutely undue influence. But John is telling, being a caregiver and telling mom, if you don't sign a will, leaving everything to me and cutting out my siblings, I'm going to put you in a nursing home.
Right.
Is that an undue influence?
It's influence.
Sure, certainly it's influence, but is it overpowering enough to meet the legal standard? And
Yeah, and that I would say generally it shouldn't be.
Right.
And we'll talk about that here in the last break. We got to take one more commercial break, so stick around. We'll be right back. Yeah, this should be a high burden, because, and again, this goes back to what you were saying about being a free American, right? If I let's say there's something you want really bad, right? You don't want to go to a nursing home.
Yeah.
And I say, okay, well, I'm here caring for you, and I'll keep caring for you, and you're going to leave me all of your stuff. And if you don't, I'm not going to care for you. And since nobody else is going to do it, your butt's going to the nursing home.
Yep. Happens all the time.
Happens all the time.
It does.
But you could refuse. Your will has not been overpowered.
Yeah.
Right? It's something that you want versus what you don't want. You're making a compromise of
right, and you're understanding what you're doing.
Right, but we have not overpowered overpowered your mind to the extent that you wouldn't have done this anyway. It should be a much higher bar than that.
Yeah.
We've seen people be very nasty, particularly to their own family. In fact, those are often the nastiest ones, where people will say, "Yeah, if you don't do this, I'm going to put you in a nursing home. If you don't do this, you can't see the grandkids. If you don't do this, whatever." But it usually does not rise to the level of overpowering you to do it. I mean, theoretically, you could just tell them, well, yes, I'm going to do it.
And then not do it.
And then not do it. Or even if you did do it, then when they weren't around,
change it back.
you could change it back. Yeah. Right? So you have a lot of power to do those sort of things. So you've got to have some accumulation of circumstances in all of that.
And the law historically has really wanted this to be a high bar because I think the law has recognized that there are often trade-offs by seniors and older folks and what they do in their wills and to get what they want. But they didn't want litigation on every single will that did something besides leave everything equally to the kids.
Yeah, no. Well, and Lisa, when you started reading this case this morning, and then here again as I was going over it, I actually, there was a half a second where it crossed my mind that this was one of my cases.
Right.
Because I started thinking about it, and I had actually driven out to I believe it was outside of Sulphur Springs or Mount Pleasant, did a home visit for a woman that was dying.
Oh yeah, I remember that case. Yeah. Let's see.
And ended up leaving everything to
her friend.
To her friend.
Yeah.
So, all right, here we go.
All right, everybody, welcome back to our final segment on today's Aging Insight. We're talking about a case out of Tyler, Texas, that concerns a lady making a will that left everything to a fairly new friend who had provided her with some transportation and some emotional support while the lady was estranged from her family. Ultimately, the will was offered for probate by the heir beneficiary.
Yeah.
And the lady's testator's daughter came in and contested this will, claiming that mom made the will because she was unduly influenced by the new friend to make the will that was presented. And in this case, at the trial court level, there was a bench trial, John, which means that there was not a jury. This was all just presented to the judge. And the judge found that the daughter's claim should prevail, that the daughter did prove that mom's will was made because she was unduly influenced, that her own will, and by that I mean willpower,
yep.
was overpowered by her new friend to make this the will that she did. Some factors that the court looked at was the fact that the new friend was basically her sole mode of transportation.
Yep.
And
her caregiver
and a caregiver and
yep.
an emotional supportive person. Also looked at the fact that appeared that the friend had isolated the lady even when family did try to reach out to her. Also, that the will was actually signed and executed in the lady's home with her friend present at the time of the execution.
Yep.
And let's see, what else have we got here? Oh, and that the friend had a motivation.
Yeah, that the friend had some motivation.
Because she had her own financial difficulties, and that this estate, should she get it, would help her resolve those.
Yeah, that's right. The thing is that this, again, we go back, this is a set of bad facts with this lady, because the timing and the way everything goes. But it appears from the outset, at least in my opinion here, it looks from the outset like the trial court and the appellate court, both, they just didn't like this.
Yeah, they didn't.
They didn't like the fact that this lady cut out her kids and left everything to this friend. To this
new friend, yeah. So the daughter prevailed at the trial court level, but it didn't end there. The friend appealed to the Court of Appeals. And John, I have to say that if the friend had been in my office and asked my legal opinion based on the history of cases concerning undue influence in the state of Texas, I probably would have said, gee, I don't think the trial court had it. Undue influence is so difficult to prevail on.
Yeah.
That I just don't think the facts here are so heavy enough to actually get you there. So I can understand why the lawyer and the friend appealed, because, I might have.
Right. Well, and I guess the thing is let's look at some of the things that they pointed out here. The influencer's motive, right? They talked about the fact that she owed $30-something thousand
in a criminal
case, and now she's a beneficiary of this, so she has motive. Let me just be clear. Everybody got a motive.
Yeah, every claim that we've ever heard from a family of undue influence, the person they are alleging was the influencer, had a motive. Maybe they had credit card bills and debts. Maybe they just didn't want to work and they wanted to have all of mom and dad's assets for themselves. I mean, the motive is greed. You don't have to have a separate criminal case hanging over your head.
Yeah, and your poorness, your debt situation, none of that has any factors on greed.
Right.
And greed. They didn't ask the daughter. I mean, the daughter's contesting this whole case, but they didn't get into the daughter's background and look at her credit score.
Yeah, maybe she filed bankruptcy a couple of years ago. Maybe she's in a bankruptcy plan. We don't know. They don't get into that. So I think the fact that the court, emphasized the friend's position, gosh, that can be found in every single case. So I don't find that to be a distinguishing issue.
Yeah, they also completely gloss over the divorce and everything that's going on in the divorce.
Yeah, so if in this case, if the kids had taken the husband's side and the woman felt isolated from her family initially just by their own choices, then I could see you might want to make a will that cut those kids out.
Yeah, absolutely. And I've done it. I've sat there and drafted wills for people under those circumstances. I had somebody just in the last couple of weeks that came to me that after that they originally come to me after their divorce, where their kids had completely sided with their spouse. They wanted to leave them very little.
Right.
And leave the rest to other people. And now here we are a couple of years later, the relationship has not built back.
Yeah.
And so now they're cutting them out altogether.
Yeah. So they kind of did it in degrees. They cut them out a little and now they're cutting them out a lot.
Yeah. But you know what? I mean, that's a perfectly normal reaction to family dysfunction.
Yeah.
I've had lots of people leave out their spouses, their kids, because of some sort of family dysfunction and all of that.
Yeah.
It happens all the time. So there's nothing about that that's unusual. And I'm thinking about this lady, and okay, so she's got this. Think about what she's got going on. She's dying. She knows she's dying. She's in the middle of a divorce for whatever reason, which they gloss over, so we don't know. And her kids have I mean, to say that they've taken the side of one person has got to be, it's pretty serious, because these are
Right.
adult children.
Right.
So if you're, quote, taking the side of somebody, that means you're just basically being a jerk to the other side.
Yeah. Perhaps. Yeah.
I mean, it's not like the kids are 14 and they're saying, well, I want to live with dad.
Yeah.
These are adult children that are living on their own.
Yeah.
Right. So you got all of that. And if this lady's sitting there thinking, well, you know, everybody I thought loved me doesn't.
Right. And then she still had, she still had to get around to these appointments and things like that. And here this friend, for whatever reason, was willing to provide that. That's not really an unusual circumstance. We often get a caregiver or a family member who sacrifices their life to make these things happen for the ill or aged person.
Yeah, there was lots of bad facts in this case.
Yeah, definitely.
There's lots of bad facts, but nothing in there leads me to believe that the influencer overpowered the lady's mind.
Yeah, there's no doubt there was influence, but of course, we weren't in the courtroom.
That's
we don't
true.
know.
Yeah, we didn't hear the testimony.
But just from reading the appellate decision, I'm just not seeing anything that tells me that the deceased lady's will was overpowered by her friend.
Yep. No, I'm not really feeling it. I think it's certainly some creepy stuff going on. Don't get me wrong.
Yeah.
And I think the judge in the case, the primary judge, he probably got a pretty creepy vibe out of this lady, if I were guessing.
Yeah, and how people present in a courtroom, and there's a lot of intangibles that go into actually the trial court level.
Right.
So
all of that adds up too. But I guess the thing is one thing this case does do is it sets a bit of a precedent that it could be a little easier, at least if you're in the Tyler area, to defeat a will based on undue influence. So anyway, good information to know. And if you are doing something that's not a straight up disposition,
a natural
disposition, you need to be getting with an attorney privately and going over all of that well in advance.
Yes.
That's how you keep all of that from happening. All right. Well, we're here at the end of the show. We will see you next weekend on another edition of Aging Insight. Until then, have a good one.
Bye-bye.
And goodbye to all of y'all in Facebook land.